Today we're going to be talking about HIPAA and maintaining the privacy of healthcare information. This is not the abbreviation for HIPAA. It's more like this. The Health Insurance Portability and Accountability Act of 1996. The act actually had two parts to it, and it was actually enacted under President Bush the first way back in 1997. The goal of that was to do a number of things that everyone probably would agree with. That would include prohibiting health insurers from discriminating against people with pre-existing conditions or other health factors. It also had a Title II, and that was what was aptly named, of course, Administrative Simplification and Privacy. And that's where what has become known and is popularly referred to as HIPAA. Title II did a number of things that, again, most people would agree with. It included simplifying the process of submitting healthcare claims. The Form 1500 was standardized to reduce a few of the games of health insurers of denying payments, or each of them having a different system of how they accepted forms for reimbursement and so forth. Not to say that that is perfect yet, but it did improve that somewhat. Title II also had two additional sectors. One was involved privacy of healthcare information, and the third was the security requirements for healthcare information. A term of art that is part and parcel of HIPAA is a covered entity. For our purposes, we can assume that a covered entity is any healthcare provider that you may be employed by these days. Unless you literally live in a cave with no electronics, you are probably a covered entity if you are providing any healthcare services these days. The trigger is that if there's any electronic transactions, and that ranges from submission of information to a health insurance company to an EMR to everything but a fax machine. So you can assume that in fact you do work for a covered entity. If you want to drill down a little bit, this is a government form that helps you understand if in fact you are a covered entity. Take my word for it, you probably are a covered entity. It is a little more problematic that HIPAA may apply to a lot of entities that don't really consider themselves healthcare providers. It may pop up in a company's flexible spending accounts, in their reimbursement arrangements. There may be a defined contribution plan, EAP programs, etc., that HIPAA compliance is required. Let's kind of jump into, okay, what is HIPAA and what isn't it? I like to talk about HIPAA kind of in comparison to the Bible. Many people cite it and claim that it applies, but they never actually have read it. And that's often true of HIPAA. HIPAA, 90% of it is common sense. 90% of it probably pre-existed to a certain extent before it was enacted. HIPAA, probably the biggest impact is the amount of documentation that's required. So what is a covered entity required to do? It's required to protect healthcare information, referred to as protected or personal health information, PHI. There are exceptions that does not require a patient's authorization for release, and that would include payment, treatment, and healthcare operations. For example, two healthcare providers do not have to have the authorization at the bedside of a patient to talk about the healthcare of that patient. The healthcare entity is required to disclose the minimum necessary in all situations, and in particularly in the setting of payment and healthcare operations. Something that is a bit new is that a covered entity must notify a patient of their rights to privacy, They have to also advise the patient of how the entity is going to protect the privacy of that patient. If any of you have a credit card, you have seen this sort of information because HIPAA looks a lot like the Graham-Bliley Act or the Fair Credit Reporting Act, which requires that a credit card company advise all of its cardholders about the privacy practices of the company. Exactly the same sort of process in HIPAA. Also, in addition of HIPAA is that one has to obtain the signature of the patient to confirm that in fact they've been informed of that information. A covered entity has to obtain a patient's written authorization in most settings to release PHI. The exceptions are what we referred to previously, which is variously referred to as PTO or TPO, depending upon what your priority is. The reference to healthcare operations are all of the things that go on internally in a healthcare organization. That may be peer review, it may be quality assurance, it may be revenue cycle management, any of the things that where healthcare information may be a part of, but is solely being used by employees of the organization to improve or to perform the functions of the healthcare organization. Conversely, a covered entity must give a patient access to their healthcare information. They also must give them the opportunity to change any information that is incorrect, and you'll see that kind of protocol discussed in the textbook. And the covered entity must keep an accounting of all the disclosures of PHI for the patient that are not within the PTO exception. This is an opportunity for an organization to stumble in that there may be a breach of confidentiality and that isn't documented as a release, and so therefore the entity has two problems: the breach and the failures to notify the patient. A covered entity also must, starting down the path of the documentation and the structure of protecting healthcare information, must appoint a privacy officer and a contact person for each organization. The privacy officer is the person who is in charge of assuring that HIPAA is being complied with. The contact person is the person which a patient may contact to either authorize release of information or to correct information or have some other interaction in the management of their PHI. A covered entity also must formally adopt policies and procedures managing healthcare information, and it must make sure that those documents are kept up to date, and that is of course the challenge. In smaller organizations, quite often they will go through the process, often buying a prepackaged sort of set of policies and procedures, and then put them on the shelf and not look at them again. It's very important that in fact those be kept up to date. The entity also must provide training to all of the employees, and that is an ongoing requirement. It is not just a one and done sort of phenomena. Maybe orientation training, but there also an entity is required to have ongoing training, particularly if there is an issue, making sure that corrective action is being taken. HIPAA is not new. It actually went into force back in April of 2003. When I was lecturing on this before HIPAA coming into effect, we were worried that the lights wouldn't come on, that the sun would not rise that day, all the calamities that we feared with Y2K. Well, in fact, we did survive that auspicious date and have lived to tell the story. This is just simply a listing of all the possibilities for you to be fined or go to jail for violations. The feds do enforce the statute. They are particularly harsh with those who intentionally misappropriate information, and also will sanction institutions for failing to comply. Let's look at a couple of situations where it will come up in practice as to PHI and how do we use it, not use it, and so forth. It's a fact of life that some information is going to be disclosed incidentally, accidentally, in any healthcare organization. It is not possible to take care of patients in a busy emergency room without some information being overheard by other people. The goal of HIPAA is that of any healthcare organization is to protect a patient's privacy as much as possible, but it is not an absolute requirement. The goal is be sensible about it. Staff should not be talking about patients in elevators. The staff should not be gossiping in the cafeteria. But there are times when some information is going to be disclosed. And the requirement on the institution is to use reasonable safeguards, such as making sure that computer monitors aren't visible to visitors, that whiteboards are not in public areas that would have patients' names and conditions and so forth listed on them, and that any information that does have to be disclosed is the minimum necessary. What is still permissible, and this took a little while for folks to understand, is that sign-in sheets in a waiting room are still permitted. They should not include diagnoses or any other personal information beyond name and healthcare provider being seen. And many organizations, of course, have figured out ways to work around that, such as having removable stickers once a patient signs in so they can pop them off and take them away. You can keep a patient's chart at the bedside. With the advent of EMRs, that is kind of a historic note. And there is still permitted that physicians and nurses can talk to each other. There was a fear when this was enacted that in fact there would have to be this kind of soundproof booth that any conversation between healthcare providers would have to take place in. That is not required by HIPAA. Let's look a little bit at marketing, which you may be involved in as a healthcare provider. Information about patients in a facility can be used to a limited extent, but it does require that the patient give prior written authorization if they are going to be marketed to. There are some exceptions, such as face-to-face encounters. A healthcare provider is permitted to talk to a patient about what products and services may be of benefit to them, whether that is, for example, a support group, a walker, a particular medication, whatever that's available through the organization. And there is also an exception about promotional gifts of nominal values. We don't run across that very often. What is forbidden is the former profit center of selling patient lists without the patient's prior authorization. And this was a common practice in my own past. I was somewhat perturbed to receive a mailer from one of the pharmacies, one of the national chain pharmacies, addressed to Bernie Adams, advertising a new form of insulin. I, in fact, certainly had, Bernie had never been to that pharmacy. Bernie had never purchased insulin because Bernie was a cat. And besides that, he had also passed away before this was received. That practice is now prohibited without the written authorization of the patient. You also can't share it with other folks, such as if your institution wanted to share all of your mailing lists with a DME provider or with a retirement community or something of that nature. Again, that requires a prior authorization by the patient. You are permitted, of course, to talk with your patients about treatment options. You can talk with them about discounts and so forth that may be available through your organization. That's fine. And you can market to them for fundraising as long as you only use demographics, i.e. You're not singling them out because they were a cardiac patient, but because they were a patient who is between the ages of 40 and 60 and that they live in a certain zip code. And of course, the patient always has the opportunity, or should have the opportunity, to opt out of that sort of marketing. In the old days, we used to talk about release of medical records in the EMR era. We don't really release records as much as we used to because for two reasons. One is that the EMR, everything's available through the portal. But secondly, the terminology has changed. If you are HIP, the term is that a patient authorizes disclosure of their information, and that must be in writing. It should be done in advance of actual release of the information, and it should be clear what information is going to be released. We've talked about the minimum necessary previously. This comes up in interactions between a healthcare provider and a healthcare insurance company, in that the default by an office staff may be simply to ship the entire chart to the healthcare provider. That's not permitted. It has to be limited and focused to what is the issue for the patient's care. One of the heavy documentation areas that every healthcare entity has to wrestle with are the requirement that business associates enter into an agreement to protect PHI. A business associate is anyone who is a vendor or an independent contractor involved with your entity, your covered entity, and has access to PHI. So it does not include the janitor. It shouldn't include the janitor. It shouldn't include the landscapers. Shouldn't include the plumbers. However, it is not bad practice to make sure that those people understand the discretion that's required when they are in your facility. A business associate is required to, under the current regulations, protect PHI as carefully as you do as a covered entity. And if they subcontract, their subcontractor must also protect that PHI. There are terms that one can negotiate within a business associate agreement. One, for example, is if there is a inadvertent breach of information by the business associate, who is going to pay for the costs of cleaning up that mess, who actually owns the data at the end of the process. And this may come up, for example, in a clinical study. This may come up when a billing agency is handling data. They may be looking to use that information to develop patterns and averages and norms and that sort of thing. And also a term to consider is if there is a breach, is there a period in which the business associate can cure that breach and the contract continues, or is it an immediate termination of that contract? Limited data set is not something you're going to run across very much, but it is in essence a statistical package that is often important in doing public health analysis. It may be that your entity wants to send a limited data set to an outside vendor to crunch the numbers to see, okay, what does it cost to provide urology care or obstetric care in our entity. The goal is that has to be a de-identified set so that no one can look at that data and say, oh yeah, that's Mrs. Smith. It has to be scrubbed of all personal identifiers. The security rule we'll talk about under cybersecurity, but it was originally released in February of '03. It actually had a newer rendition that came out more recently, but it only applies to electronic data. You're going to run into some confounding situations with HIPAA. For example, how do you handle impaired providers? Where does workers' comp kind of fit into this mix? Complying with OSHA, which you have certain documentation requirements for OSHA. You have certain documentation requirements for HIPAA as well as privacy concerns for HIPAA. And all of these other sorts of issues that pop up from time to time that actually keeps me employed. So don't become too clever in that. Feel free to give me a call. With that, that ends the pain of this conversation. In your textbook, you'll see a much more in-depth dive on the topics that we've talked about, and feel free to follow up with me if you have any questions on this important topic.